CL 650 presents your source for leading-edge news and information on today's hottest products and services. This is Experts on Call.
Well, good evening and welcome to QuayPacific's Talk About Strata. This is the show where we provide you with information about strata corporations, the legislation, the kind of circumstances that affect your property, your investment, where you live, how you live, and provide you hopefully with some information to understand what's happening in the industry. My name's Tony Giventu. I'm your host, and in the studio tonight we have Shannon Salter, who is the chair of the Civil Resolution Tribunal, and welcome to the studio, Shannon.
Thanks, Tony.
And Adrian Murray, who is a lawyer with Hammerberg and Associates, and who does nothing but practice pretty much strata law. And so I was going to say, after all this practice, you must be getting it right after all this time.
Well, good evening, Tony. Good to see you again.
So, Shannon, what we've seen in the last week was the amendments to the Civil Resolution Tribunal Act, which are going to have a lot of implications on how the tribunal functions, operates, and so maybe if you can give us a little bit of a rundown of what those changes are, it'd be a great way to start with the listeners.
Sure. So the Civil Resolution Tribunal Act came into effect in 2012, and as you mentioned a couple of weeks ago, the amendments to that act were passed by the legislature. And so really these amendments do a few things, but the most important thing they do is they create the ability for the tribunal to become mandatory after a period of time. So likely what you're going to see is that the tribunal will start up. It will begin its operations to be voluntary for the first year. There's one important exception to that, though. It's not voluntary for strata corporations. Strata corporations have to use the tribunal if they're asked to do so. But in general, it will be voluntary for the first year or so. And that's for a lot of strata claims. I know we'll talk about that a bit more in a moment. And also small claims, which are everyday civil claims under $25,000. So after this voluntary period of about a year, what will happen is the tribunal will become mandatory for all strata property claims within its jurisdiction, as well as for certain small claims. And what the likely limit is there is that all claims for $10,000 or less that would normally go to the small claims court would have to come to the CRT first.
So just for the listener's perspective, when you say that stratas are mandatory to start, what that really means is on a day-to-day basis of business, if I don't like something that my strata is doing and I believe that they're not complying with the act or they're not complying with the bylaws, or they've done something that's been a damage to our property without our consent, I will be able to start a dispute and the strata has no choice. They're going to have to participate in the dispute.
That's right. So you can invite, quote unquote, the strata to use the CRT to resolve your dispute,
right,
and the strata corporation would have to use the CRT.
So from the listener's perspective, though, what everybody wants to know is, when is this going to happen?
Well, and this is a bit of a moving target. We're building this technology to let us do this from scratch. It's the first technology being built to do this for the justice system, and so it's really innovative, but it also is challenging and complex, and we want to make sure that we do it right. We're hoping to be able to launch the first part of the tribunal, which is something we're calling the Solution Explorer. It's a set of online tools for people to get legal information and tools and resources to resolve their own dispute. We're hoping to launch that in July and then have the remaining part of the tribunal, which is the dispute resolution part of it, ready by the end of the year. I should caution, though, that that's our best understanding right now. This depends on the technology build. So that is going ahead full steam right now, but and we're according to schedule right now, but you never know with technology projects, and we want to make sure that it is ready for prime time, that it works properly before we roll it out to the public.
So the Solution Explorer is kind of a self-diagnosis. It's where people can go in, whether you're an owner, a tenant, occupant, you're a strata council member. You can go into the Solution Explorer and you'll be able to go through a sequence of analytical questions, essentially, that are going to help you to define what your dispute's about. And I think we can, to put it in simple words, most disputes between most people on a civil basis are, I either want somebody to do something or stop doing something, or I want somebody to pay for something, right? And so most of the disputes in strata are pretty much the same thing. They evolve around the strata doing or not doing something, or costs that are associated with the strata, and somehow I may have had costs that I want to resolve. So when we go through the Solution Explorer, people are going to be able to get resources. What is the objective of the Solution Explorer?
Well, just as you say, Tony, it's a way for people to diagnose their problem. Oftentimes people know they have a dispute, but they don't know what kind of law applies or what their rights might be in a particular situation. And we can tell them a little bit about that, but first we need to find out a bit more about their problem. And the way we do that is by asking them questions. So really what the Solution Explorer is what we call a guided pathway approach to giving people information.
Right.
We know it's not very useful just to scan a bunch of PDFs and throw them up online, because you don't maybe want 40 pages on strata law. You want to know how you can resolve your particular parking dispute, for example. So by asking you some questions, we can find out more about your issue. We can give you targeted pieces of information and targeted tools like a template letter you might send to your strata corporation. And to populate those questions and answers, we rely on experts. So this isn't a form of robotic justice. Really, this is humans who have volunteered their time, people like you, Tony. Tony's
Right.
volunteered hundreds of hours of his own time to give us the information that we know people are going to need or want. And so we've relied on a lot of subject matter experts to come up with the legal information that's going to help people through the Solution Explorer.
So Adrian, what do you think of transition to tribunal as we go from a traditional court system into a what appears less formal, but will still have formality to it? It becomes much more accessible to the public.
Long overdue, long overdue. I think that in so many situations we've seen circumstances where there's an issue, whether it's the strata in respect of the conduct of an owner, or an owner concerned with what a strata's decision has or lack of decision has been, and an inability for either party to access any reasonable means of dispute resolution on the basis of affordability. We'll probably talk a little bit later today about bylaw enforcement.
Mm-hmm.
And the idea that in order to enforce a bylaw, there's a fining mechanism, but if we really want to enforce a bylaw, we need to get a court order ordering that person to comply with the bylaws, to cease or to do something or not do something, essentially,
Right.
as you've said. That's expensive.
Mm-hmm.
It's immensely expensive. Owners have to agree to spend the money to do that. And as much as owners on the one hand want to have their bylaws enforced, they're really not anxious to spend out-of-pocket money, in some cases in the hundreds of thousands of dollars. So it's long overdue.
So in a way, tribunal is going to give us a mechanism for more of a regulatory compliance. So strata corporations who are not complying with the act, with their bylaws, that are kind of acting outside of the boundaries and to the detriment of the owners or a small group of owners, will now have a mechanism to be able to get the stratas into some basic compliance. And that also, in the long term, when you deal with the economic perspective, as you raised, that has a huge impact on housing affordability as well.
Well, I also think that there's going to be another spin-off benefit from this, and that is that strata councils will know, and owners, I shouldn't leave them out, but I think primarily strata councils will know that they have to be held to account. Because today I have heard council members express a view that, well, we don't really need to worry about dealing with this because they're not going to sue us anyway. They haven't got the means or the interest to take us to court. So there's a lack of accountability on the part of the strata council. And courts, and the theory is that if we don't like what a council's doing, we elect a new council at the next AGM. But that's, again, much more theoretically, the concept is theoretical rather than practical, because sometimes we have trouble getting people to even stand for council. So we've got this council, they know they're in power, they know they've got control. With the coming of the tribunal, and as it's up and running, a council that knows that any owner can bring them to account at the tribunal, and they will have to, and may be ordered to comply with the act, I think that's going to make a huge difference in the behavior at the front end. So while there may be a huge flux of complaints, I'm actually anticipating that there'll be, as time goes by, fewer and fewer issues, because councils now know that they have to comply with the act, and that they are accountable, and that there's procedures that have to be followed.
So Shannon, think about the accountability cycle. Walk us through from the day somebody enters into the Solution Explorer till 60 or 90 days later, where they get a decision from an adjudicator. And we'll use for an example a strata council who's simply refusing to provide records and documents that the Act requires them to disclose.
Right. So the first step would be, as you say, using the Solution Explorer. And so they'd provide some information about the nature of their dispute, what had happened, whether they'd been in communication already with the strata, whether they'd already sent a letter, whether there'd been a hearing, and then they'd be given some options and resources at the end of that to go off and resolve the dispute themselves. So the Solution Explorer will be free for everyone. You won't need to start a claim with the CRT to use it, and it will be accessible 24 hours a day, 7 days a week, wherever there's an internet connection. So it's really a very low, no cost, no commitment way just to find out how you can go about solving your own problem. So at that point, the person could go off and maybe send a letter to their strata council. They could attempt to resolve the dispute themselves. But if that didn't work, then they could come back and with a click of a button, start a CRT claim. So they'd provide information about their claim and they'd pay a fee. And then they'd go from there. So the next step would be an opportunity to negotiate directly with the strata council. That doesn't involve the tribunal. It just puts the two parties together so they can try and resolve their own dispute. Failing that, though, the heart of the tribunal, I think, and one of the most innovative things about it, beyond being online, is that we're putting a lot of resources into a phase we call facilitation. And there, a dispute resolution professional, someone with mediation or facilitation training, would work with the parties over a period of time to help them reach a consensual agreement. So in the case you mentioned, that might be reaching an agreement about which records are provided and under what circumstances. And if the parties are able to agree, then that agreement can be turned into a binding tribunal order, which is also enforceable as a court order.
Right.
If they weren't able to reach an agreement, though, then the last resort is adjudication. And there, an adjudicator who's an expert tribunal member, somebody with experience in strata matters, somebody with a law degree, legal experience, and adjudicative experience in addition to having strata experience, that expert would look at all of the evidence, look at the parties' arguments, and reach a binding decision in writing. That, too, as a tribunal order, would be enforceable after a period of time as a court order.
So ultimately, we go from, we started the Solution Explorer, we get through the system, we end up with an adjudicated order. So what if the strata doesn't comply with the order?
Then you're left with your traditional enforcement mechanisms. You would have to go to court and attempt to enforce the order through that method. But what we can do is get people through the process quite quickly. So even though it sounded quite long, what I just went through, we're aiming for that entire process to take about 60 days.
Right.
And much shorter than that if people are able to resolve their dispute themselves earlier in the process.
So as an owner, I now have an accessible way to get into a compliance system that's ultimately going to force my strata into complying with the legislation.
Yeah, all in a short period of time for a very modest amount of money. And we know that those are currently obstacles for people to enforce their strata rights.
So here's a good example, Adrian, and we'll probably finish this after the break, I think. But an owner makes an application to a strata for a hardship exemption. Strata has a bylaw that prohibits rentals. The owner makes an application for a hardship exemption. The strata knows this person's in hardship anyhow, and they probably don't have money to go to court. They deny the hardship. It's a complaint that I hear frequently. The strata just simply says, well, we know she doesn't have any money, so she's not going to end up going to court or doing anything about it, so let's just deny the hardship, and that'll solve our problem. This individual has the ability now to use a tribunal system where they're not exposed to significant financial cost, and that they actually get an order out of it. So this is one of the areas that I think really is a good contribution to society.
Oh, I think it's one of many, but
Yeah.
absolutely. And this is, it's again that idea that there's got to be an opportunity for an owner to pursue a decision. It's the council's made a decision. I might disagree with it. It may be the right decision, but I'm disagreeing with it. And as an owner, I need to have some mechanism to take it to another level. And today, I don't have that.
Yeah, so I'm already in hardship, They know they're in hardship. They say no. My hardship gets worse, which generally means I've either gone into bankruptcy or forced to fire sale my unit because I have a greater problem, which creates just so much unfairness.
Well, and it's interesting when you mention hardship, because there's some stratas out there that are just obsessively terrified about having a tenant. And for that reason, they will go to all extremes, including almost not even considering a hardship application in the substantive aspects of it, because they don't want to have a tenant. So, neither approach is appropriate, but an owner in that position has no place to go.
I'm Tony Juventu. I have Shannon Salter, the chair of the Civil Resolution Tribunal, and Adrian Murray, who is a lawyer practicing strata law in British Columbia, and we'll be back right after these messages.
This is Experts on Call on CIL 650.